My name is Bernard Smith. I am a retired lawyer who spent over 30 years prosecuting criminal cases for the federal government. I am a married father of 4 grown children. I speak to you today about Issue 1, a proposed amendment to the Ohio Constitution, which will be on the ballot on November 7, 2023. If approved by Ohio's voters, this amendment would effectively create a new state constitutional right to abortion through all 9 months of the pregnancy of a woman up to the moment of birth. And as to minors under the age of 18 who become pregnant and are considering an abortion, it would prevent the state from requiring that parents even be notified about, let alone consent to, what their own child is pondering. The proposed amendment also would empower child sex abusers who impregnate minors to hide their misconduct. I urge you to vote no on Issue 1. Although I am Catholic and personally object to abortion on religious grounds, today I discuss other problems with the proposed constitutional amendment that are sufficient in and of themselves to warrant voting no on Issue 1, religious considerations entirely aside. I speak today in my personal capacity and not as the representative of any institution or organization. For a copy of the text of the proposed constitutional amendment that would become law if enacted in November, please see the document attached to this communication. This actual text of the proposed amendment should not be confused with the summary of the amendment, which will appear on the ballot when a voter enters the voting booth on Election Day. My fellow citizens, legal language creating a new constitutional right should be clear. The language of the proposed constitutional amendment is anything but clear. The first sentence of the proposed amendment states, quote, "Every individual has a right to make and carry out one's own reproductive decisions, including but not limited to decisions on contraception, fertility treatment, continuing one's own pregnancy, miscarriage care, and abortion," end quote. The phrase, "including but not limited to," is key. This phrase always means that there exist other unspecified items that are covered. Here, those other unspecified items would be constitutional rights. In short, if citizens vote yes on Issue 1, it is impossible for those voters to know the full scope of what they are approving. It would be up to the court system at a future time to determine what those other presently unspecified constitutional rights are. Voters should reject such vague language and vote no on Issue 1. If new constitutional rights are to be created, it should be done expressly and clearly so that voters know what they have approved. Such knowledge cannot be obtained from the vague language of the proposed amendment as written. A second problem with the proposed amendment involves the question of who would possess the newly created state constitutional right to abortion. The first sentence of the proposed amendment states that every individual would possess a constitutional right to abortion. The word every is universal and all-encompassing. Hence, because the proposed amendment literally applies to all individuals, it does not distinguish between adults and minors under the age of 18 who become pregnant. This failure to distinguish between adults and minors who become pregnant will result in parents losing their parental right to guide their own children when it comes to abortion decisions. Why is this so? In pertinent part, the second paragraph of the proposed amendment says that, quote, "The state shall not, directly or indirectly, burden, penalize, prohibit, interfere with, or discriminate against an individual's voluntary exercise of this right," end quote, to abortion. The key words here are burden and interfere with. Under that language, state laws requiring that parents be notified that their own child is considering an abortion or consent to such a procedure would constitutionally be invalidated and nullified. Notifying the parents that their minor child has become pregnant or soliciting their consent to the abortion which the minor may desire would constitute a burden upon or interference with the minor child's right to abortion. Remember, the language of the proposed amendment does not distinguish between adults and minors. Citizens should vote no on issue 1 because its passage would destroy the parent's right to guide their own child in the most important decision that that minor child could possibly be making in her young life. Third, language in the proposed amendment purporting to protect viable unborn children is actually nullified by other provisions. True enough, the amendment's third paragraph states that, quote, abortion may be prohibited after fetal viability, end quote. But that supposedly protective language is then undercut by other language and in 2 ways. To begin, the amendment's fourth paragraph states that, quote, the treating physician, end quote, who of course is the abortion provider, will decide on a, quote, case-by-case basis, unquote, whether the unborn child is viable. The amendment does not define when an unborn child becomes viable in terms of a number of weeks or months of gestation. Rather, this decision is left to the abortion provider to make on a case-by-case basis. Abortion providers, who have an economic incentive to perform and charge fees for abortion procedures, will often find that the unborn child is not viable. Further, and perhaps even more importantly, if the abortion provider finds that the unborn child is viable, the abortionist may still perform the abortion if, quote, necessary to protect the pregnant patient's life or health, end quote. Please note that this exception to the viable unborn child protection is stated disjunctively with the word or. Only the pregnant woman's health need be at issue, not her life. And courts construing the term health have included mental health conditions such as anxiety or stress, or even family and age factors as being health-related factors. In short, the exceptions to the viable unborn child protection are so broad that they swallow the supposed protection altogether. Make no mistake, the proposed amendment effectively creates a new state constitutional right to abortion through all 9 months of pregnancy, right up to the moment of birth. The amendment language purporting to provide protection to viable unborn children is therefore deceptive, providing another reason to vote no on issue 1. Finally, the proposed amendment would create a state constitutional right for child sexual abusers to hide their misconduct. The amendment's second paragraph says that the state shall not, directly or indirectly, penalize, prohibit, or interfere with, quote, a person or entity that assists an individual exercising this right, end quote, to abortion. This language would, for example, enable a school employee, a sports coach, or a teen employer to impregnate a minor child in possible violation of institutional policy or even state criminal law, and then hide such potential violations of policy or state criminal law by procuring an abortion for the mild child who the adult sexually abused. Such cover-up abortions may also allow the child's sexual abuser to perpetrate the abuse against the same minor victim again. The proposed amendment, recall, would prohibit the state from enacting any prohibition or penalty upon a person who assists another to obtain an abortion. Although the amendment would not legalize the underlying sexual misconduct, it would protect the child abusers who arrange cover-up abortions for their victims. Ohio citizens should reject a constitutional amendment that would render the state powerless to prevent sexual abusers from covering up their gross and possibly illegal misconduct against minors. For all the reasons discussed today, I urge voters to vote no on issue 1 on November 7th. Thank you.